Secretary of State to determine the appeal that's been made by Catesby Strategic Land Limited relating to a refusal of planning permission by Malden District Council. As we know, it's an outline application for up to 160 dwellings with affordable housing, bungalows, office hubs, floor space, children's day nursery, associated parking, community park, a sustainable urban drainage system and associated infrastructure on land north of the Groves, Burnham Road, Latchingdon. Just the usual reminders, please, if people could turn their telephones on silent or turn them so they don't ring, so we don't get disturbances. That would be much appreciated. I haven't been advised that there's any alarm today, fire alarm, so I assume if one goes off, we need to evacuate the building. Is that correct? Thank you. And we were advised earlier in the week that the exit is there, or I think that's the most direct exit. Yeah. Right now, what we have decided to do, following liaison between the parties, is to have a short session today on the conditions in the event I was minded to allow the appeal, and we've decided to actually do the closings in writing. So Mr. Wilcox will submit his closings by close of play today, and Mr. Cannock will then submit his closings tomorrow, close of play. That's to allow the appellant to have the final word. So we're still within the timetable that was set out. We were programmed for 4 days. So once I receive Mr. Cannock's closing submissions tomorrow, we'll be in a position to close the inquiry. So I hope that's clear to everybody. As I say, today's session I'm hoping will be reasonably short, and we're simply going through the conditions that could be applied were I minded to allow the permission. Now, I had a look through these conditions. They do seem, my initial observations is, given that this is an outline scheme, there do seem to be an awful lot of conditions, and I do wonder whether some of these could be merged in the interests of clarity and brevity. But I think probably the easiest way is, I understand that the schedule as it's currently drafted has been agreed. So I understand that is the position.
So I think there is a few additions from us, nothing substantial, but we went through them in light of the discussions over the last 2 days. Right. There's some additions which we can pick up as we go through. So.
Okay, fine. Well, the first condition is a reserve matters standard condition that asks for the reserve matters to be submitted within 3 years. That's a standard condition. Timings, again, I thought 2 and 3 almost could potentially be merged, because it seemed to me that a way of dealing with this would simply be to have listed all the items that need to be submitted as part of a reserve matters application, rather than having lots of individual conditions. You could structure it in such a way that that reserve matters shall comprise the following: landscaping details of boundaries, gates, fences, etc., etc. Do it that way, rather than having lots and lots of different conditions. That would reduce the number of conditions. So if you had adopted that approach, it seems to me you would you could reduce things drastically and reduce the amount of text as well. I've got no particular objection to the items that. So, landscaping obviously is fine. Car parking makes sense. Cycle parking. is absolutely fine. Building heights, you talk about a 9-metre limit. Is that the sort of, is that a 2-storey house roughly? Yeah, and you're happy with that, are you? Yeah. And then the dwelling mix set out in the, that's...
So the only thing we wanted to add to that was obviously the offer of the bungalows.
Yeah.
Which obviously is a 10% figure.
Yeah.
And that would appear to be the place to include the requirement for 10% of the dwellings to be bungalows. It fits in quite nicely.
Yeah, okay.
I did also wonder, sir, if, on reflection, if that needed to be a bit clearer from the council's perspective. It's referring obviously to the local housing needs assessment, but it just says the housing mix requirement. And I'm not sure if it's absolutely going to be clear what that housing mix requirement actually is. It may be, but I just...
is that not dealt with by the planning obligation in any event? I mean, I thought the planning obligation set out the sort of percentages of...
It does for the affordable.
It does, yeah.
I think this is trying to catch the open market, sir. I think that it is actually meeting the most up-to-date need, which I guess, to follow your line of thinking, the council would be seeking in any event as part of the reserve matters. So it's perhaps just one for clarification, and with the bungalow addition, it probably just squares a nice circle.
Yeah, okay, that's fair enough. If you want to insert that there, that's absolutely fine. Archaeology, again, it seems to me a pretty standard type of condition. Biodiversity, yeah, I mean, that's fairly standard.
Apologies, sir. We had, sorry, I probably should introduce myself to inquiries. I haven't spoken before.
Yes, sorry, yes.
David Morris, I'm Planning and Operations Director at Catesby Estates.
David Morris.
Morris, yes.
Morris, okay.
At Catesby Estates, just to clarify for those, Catesby Strategic Land Limited is part of Catesby Estates. So
right, okay.
Hence
thank you.
Catesby Estates. We wondered there, so whether, having reviewed this yesterday evening, and then actually, and this may be something we discussed with the council, there is actually a biodiversity impact assessment submitted as part of the application. So it should arguably refer to both documents there. But that's something we'll discuss with the local authority. In fact, because that's where the metric is as well for BNG and securing the benefit of the additional BNG versus the 10%. And it may be that it needs to refer to both documents in that regard to make sure that the biodiversity net gain is secured.
Yeah. Is that okay with the council? Yeah. Sounds perfectly sensible. Condition 10 is great crested newts. So it's saying any works which will impact on the breeding resting place of great crested newt shall not in any circumstances commence until the local planning authority has been provided with, so it's effectively requiring licensing and so on. That seems fair enough. And then we've got a biodiversity enhancement strategy, that's condition 11. I mean, again, is there any scope for 9 and 11 to be merged, given that they sort of deal with similar matters?
Yeah,
they could. I mean, you can add 12. I mean, the LEMP is part of 11 and 10 and 11 anyway. So I
mean, it just seems to me that some of these do duplicate somewhat. I mean, it may well be that they need to be worded in such a way, sort of to capture all the elements, but they could probably be done in a single condition rather than separately. I mean, the biodiversity stuff I would have thought could could be definitely, you know, you could have a single condition for that, I would have thought.
Yeah.
I mean, the LEMP, is there much, I suppose that's landscape and ecological management plan. I don't know, is there much difference between that and... There's lots of different sort of terminology that's used these days.
I mean, one would say probably not. If you look at the criteria for the length, they do pick up most of the...
Yeah.
But I think...
Well, look, I'll leave that with you to discuss as with a view to, you know, having a look to see whether they could be merged in a effective way.
That's fine. Makes sense. Yeah.
13 is a lighting scheme. Again, that's quite understandable. So is this a lighting scheme for the sort of the roads or for the houses or for everything?
This is for everything. My reading of that linked to the biodiversity because of the...
Yeah, to try and minimise the impact. Yeah, sure. Mm-hmm. Well, that seems perfectly fair enough. Drainage condition is number 14. That's obviously quite a technical type of condition, which I assume has been requested by the flood authority.
Yes.
We have a whole series of flood conditions, don't we? I assume these are all, I mean, 15 is flooding during construction, 16 is a flooding maintenance plan, 17 requires yearly logs this is for the drainage system, I assume. Yes. 18 is foul water drainage.
So sorry to interrupt.
Yeah.
I had a query on 16. It may be that we need to just clarify this within the council, but whether or not 16 should refer to in perpetuity rather than just as long-term funding arrangements.
Details of long-term funding, yeah. In perpetuity, yeah. Any thoughts, Mr. Armstrong, on your side on that?
I think the maintenance plan will identify effectively that it's ongoing maintenance, but if
well, maybe we should just say ongoing funding arrangements. I don't know.
I don't think it really matters.
I think what you're saying is that you don't want it to stop. You want it to go on.
Yeah.
I understand that.
So just from our perspective, we've got no problem with that, because ultimately, whether it's within the management company or transferred to the water authority, whoever it may be, that will obviously be maintained in perpetuity either way. So we're comfortable with it.
Okay. Well, I have no particular preference on that. I mean, if you want to agree a form of wording, that should be okay. I mean, as I say, there do seem to be a lot of flooding conditions, but they do seem to have. I mean, I'm not sure how easy it would be to merge these because they do seem to deal with separate issues.
Yes, sir.
The only thing I wondered, sir, is whether 15, in terms of because effectively it refers to construction works, whether that could be incorporated into the construction management plan.
I think yes,
those measures could be within that document, and it covers
exactly. I think that would, in some ways, would make more sense if that was included in the construction management plan, because, as you say, that's only for the duration of the construction period. So I think that's a very sensible. Otherwise, it gets confusing. So yeah, good point. So I think that's condition 20, isn't it? The construction management plan, yeah. 19 is the system of foul drainage. Prior to the first occupation of any dwelling or building on site, the foul drainage for the development must be connected to mains drainage. Yeah. Okay. Sounds fair enough. So yes, the construction management plan. I mean, if there are any other conditions, I mean, we'll go through them obviously. But if there are any other issues that relate to the construction period, it seems to me that they would be more appropriately included in that particular condition. Okay, good. Right, so 21 is a contamination condition. Is there evidence of contamination on the site? We know?
Not that I'm aware of, sir, but what I would say is we've had a phase 1 desktop study done, and therefore, in the absence of a phase 2 intrusive survey, these tend to be quite standard conditions. So you would expect, and we would carry this out if consent was granted, that we would carry out the phase 2 geo-investigation work, which would then inform these conditions. So that's why I suspect these have been imposed now.
Fine. Okay, so I mean, the contamination conditions, they look to be pretty standard conditions. Essentially, you know, if anything comes to light, then a remediation strategy has to be drawn up. Fairly standard approach. As with all these contamination conditions, their brevity isn't their strength. They seem to be very long. It's always the same. So that 23 is also a contamination condition. 24 is a noise condition. Yeah, is this an environmental health requirement?
Yes, it is.
So this is for dwellings facing amenity spaces, is it? It just seems slightly over the top, I have to say, but I mean, are we expecting a lot of noise? I mean, this is a pretty, I would have thought Latchingdon is not the most noisy of places, is it?
There are kennels nearby.
Oh, are there? Okay. Well, any
I
thoughts?
assume that may be why it was asked for.
Well, I mean, I can understand it if you're sort of building, you know, housing on the Great West Road in London or something, but it does seem slightly over the top. But I don't know, Mr. Armstrong, or Mr. Morrison, do you have any particular view on that? I mean, I understand you're happy in principle with these conditions. I obviously have to apply the test as a decision maker as to whether it's necessary, you know, and it's not just whether you've agreed it, as it were.
Yes. Understood. I think, as Mr. Coleman said, there are kennels in the vicinity, and I believe, and I might be wrong here, so apologies, but I believe third parties may have made representations on that point separately. So I suspect the environmental health officer is just sort of covering that off. It wasn't raised by the officer as a point of objection during the determination of the application, so I'd imagine it would be fairly straightforward to discharge, but I suspect that's why that may be on there in response to those third-party queries.
Okay, well, if that's the position, then that's fair enough. And then again, 25 is again a noise condition that relates to external plant in respect of any office or nursery building.
Sorry, sir, my only question on this, having reflected on it, is whether, in the absence of detailed design for both of those, whether this was more appropriate to a reserve matters consent should one be granted, rather than actually having it now. But I'll leave.
Well, I mean, I do, you know, I do have some sympathy with that approach. I mean, there are different ways of approaching outline applications. You know, I've had situations where the council puts on, 10 conditions and that's it, and they're all quite broad, and the detailed matters are imposed at reserve matters stage. And the alternative approach is a sort of belt and braces approach where you have lots of detailed conditions. So, I mean, I've got no strong view on that. I hear what you say. I mean, I don't know from your side, do you have any particular observations?
Well, I think what was said before is correct. I think it's, in this case, because of the noise, it is because of the kennels nearby.
Yeah,
in terms of whether that's now or later.
Yeah, that's the issue, really.
I don't think there's I've asked the question.
Yeah. Okay, I don't think we have a strong view, sir.
I think that 25 relates to the noise emitting from the uses, being the office and the nursery, and hence my comment in terms of that's why it's not the kennels point is covered by 24.
I mean, I've got no strong views either way on it, really.
I mean, the point, sir, is that the council can ask for that work as part of the reserve.
Yeah.
matter.
I mean, as they could on a lot of these issues, to be perfectly honest.
I accept that, and I understand the main noise one. I understand that, and that ties in with the noise report we've done. But for the operation of two facilities, which are yet not, we don't know what they are yet, and how they're going to be used or operated, or whether there's whatever. I think it would certainly that to reduce the number of conditions. That one could probably.
Yeah, I mean, obviously, it's a belt and braces job. I mean, Mr. Coleman,
I don't think I don't think we've got any objection to leaving it to reserve
leave
matters.
it. Yeah, okay, so we could lose that one then.
It makes
potentially.
sense.
Okay. So 26 again is a noise condition that relates to the.
We're wondering whether that one could also be removed, sir, because it's obviously talking about what the future might hold.
So what does it say? Prior to the agreement of reserve matters, an assessment of noise generated by the operation of the nursery. I mean, again, you see, that could be put into a condition. As I was saying to you earlier about having a reserve matter saying it shall comprise the following items. You could say an assessment of you could include that type of thing in that condition, rather than having it as a freestanding condition that any reserve, the reserve matter shall comprise an assessment of the noise generated by the operation of the proposed nursery. I mean, I can see why you might want that, because nurseries can be quite noisy, particularly with lots of children in one place. It can be quite a noisy thing. So, I mean, I quite see the sort of the reasoning for it. But I mean, I just wonder whether it could be restructured in that way.
We again, our discussion was in and around the reserve matters point, because ultimately the outside play area for a nursery, for example, we're not quite sure yet the orientation of that versus the residential. So therefore we wondered whether that would be something that the local authority would impose at reserve matters stage, when they then have a detailed layout for that part of the development in front of them for consideration.
That does make sense. We might need to just double check the reasoning behind.
So, you're happy to take that one out as well?
Well, I think we just need to double check with colleagues to see why.
Okay.
If there was a
that's
particular
fine.
reason.
I mean, do double check. Mr. Coleman, I wonder whether I should take a note of your colleague that's sitting beside you, because
Sorry.
I'm Juliet Kirkcaldy.
Juliet.
Kirkcaldy.
How do you spell that?
Kirk.
Kirk.
Aldy.
Kirkcaldy. Okay. Thank you. Are you one of the planning officers, or?
Yes, yeah, one of the planning officers here.
Did you deal with the application, or?
No, I didn't.
Well, I'll just probably record you in the decision, because obviously you've been sort of participating in this part of the. I mean, what it might be helpful for me actually is if both sides could produce a list of witnesses and participants with their qualifications, just so I know what's what. That would be.
That's fine. So I'll append one to quite close.
Yeah.
I apologise to you for not introducing Mr.
No, I should have asked at the start, to be fair, who was going to be participating, and because initially I thought it was just going to be Mr. Coleman and Mr. Armstrong, but then of course Mr. Morris is there and Ms. Kilcaldy is also there. So it just for the record, I need to list who's participated. All right. So yeah, you're going to take further advice, Mr. Coleman, on that.
I think we've had it. I think we're happy to. What have you said?
Just to accept it.
Yeah, we accept. I suppose deferring it to the reserve matters.
Oh, okay.
Yes.
So you're happy to defer.
Yes.
Okay. Now 27 is the office hub. You're proposing restricting the hours of use between 7 o'clock in the morning and 900 hours in the evening. The appellant is saying that that's a bit restrictive. Well, I mean, as the appellant says, I mean, an office use should be, usually office uses are compatible. They're seen as compatible with residential areas. They're not
exactly so.
They're not, a use that's necessarily going to cause a nuisance. I wouldn't have thought. Ms. Coleman,
I believe this has come from the environmental health officer. I don't know any more about the background. Is that standard approach?
Yes.
Standard. Well,
I just think no work on Saturdays or Sundays. I mean, this is going to be something which is going for residents to use for their own purposes. It'll be a local facility. It's not like a normal office building where I'd understand you might want to limit it. This is a working from home type facility.
Indeed, and I mean, in a way, the other way of looking at it is when the reserve matters for the office hub come in. I mean, I would have thought that's probably the more appropriate time at which to look at the nature of the building and what restrictions may or may not be appropriate. I mean,
because we've provided these elsewhere on other sites, and for example, parish councils have taken up occupation of the office hub for part of the time in terms of their meetings of an evenings and weekends. So it offers that flexibility, therefore.
Yeah, I mean, it seems to me that it does. Given this is an outline application, this does seem to be a bit detailed, really, for this stage.
Just double checking, but I can't see why we wouldn't defer that to the reserve matters.
I mean,
I
that
agree.
seems to be a more logical approach. That you would assess the reserve, that the office hub when it comes in, as it were. You would then make an assessment as to what would be the appropriate time restrictions, if any, or what noise restrictions you might want to impose, rather than at this stage.
Yeah, no.
Yeah,
I agree with that. We are just confirming. So apologies.
Okay.
There is an obligation, so this is different to the nursery in terms of an obligation to provide it. So within the 106 agreement, there is actually an obligation to deliver this as part of the scheme, and therefore clearly that will be applied for within the reserve matters for the development.
Okay, yeah, no, we've had confirmation. That's absolutely fine.
Okay, so
We
you're
can
happy
defer
to
to reserve matters.
Yeah. Okay. So 28. Waste management. I mean, again, that's probably one that could be included in the the reserve matters condition that shall comprise the following items. Details of a waste management plan. Rather than having that as a freestanding condition. Similarly, well, we've already had a lighting condition, haven't we? Number 29.
The previous one is more related to biodiversity, I think.
Yeah.
We'd queried this before, and I believe that's the response we had a few weeks ago, was the two are different in that regard. I think the ecological officer wanted a separate one for biodiversity, I believe, but we'll leave that to the council.
Well, it seems to me that, if it's a lighting scheme, it's a lighting scheme, and it needs to be designed to take into account biodiversity. It seems ridiculous to have two sort of parallel requirements. I would have thought you would have a single condition that would say, a lighting scheme taking account of biodiversity issues. What you'd because presumably you'd want to, why would you want two conditions covering the same topic? Essentially?
I absolutely agree. We're just double checking, but yeah, absolutely agree.
Okay. Deliveries. I did think this seemed like a rather odd condition because, that could potentially prevent any deliveries to any of the houses.
Yeah, I think we were either thinking it needs to be deleted or specifically refer to the nursery or office separately, or whether such a condition for deliveries to the nursery and office would be imposed at reserved matters consent.
Mm-hmm. Well, I think, to be honest, it's an unenforceable condition, to be honest with you, and it potentially would apply to all the dwellings. That they couldn't get Amazon deliveries, at certain times of the day, which would clearly be ridiculous. So I think that one will have to go, I'm afraid. Although I see it says no, do not delete in red.
I think that was to do with clarifying that the intention is that it covers the whole of the development as opposed to just the construction period. But I agree. I can't.
Yeah, I just, to me, that seems like a condition that is. It's an unenforceable condition. I could understand if we were dealing with some sort of industrial complex where you had large lorries coming in and unloading and loading and so on, but that would apply effectively to the entire development, which would preclude even the residential units from getting deliveries, which is clearly wrong. If it seemed to be necessary in respect of the office hub to have certain restrictions, again, that's a matter that can be dealt with down the line, as it were. So I think that one, my view on that is that it's just an unenforceable condition.
We're happy with that. Happy for anything to be raised at reserved matters stage if it's to do with the office use or otherwise.
Yeah. So 31 is a tree condition. Looks pretty standard to me. 32 is a broadband condition requiring provision of superfast broadband. Again, it's quite common these days, and I think it is a policy in the local plan that requires that, so that seems to be fair enough. 33 is a conservation condition requiring it says prior to the first occupation of any building on site, details of the position, design and content of the proposed interpretation board relating to the pillbox and its historical contact shall be provided and approved in writing by the local planning authority. I've got no particular problem with that.
We've agreed with that.
That seems to be perfectly acceptable. Highways. So we've got this is the access for the northern parcel, number 34, which just gives the details of how that should be provided, and it's required prior to the first occupation.
I think the drawing numbers are a little bit behind the curve. So
okay, we'll make sure they're are included, and then the 36 is a similar condition for the southern parcel of the land. Again, we need to make sure that the plan is correct. 35 is the implementation of a zebra crossing. I mean, would this be provided? But how would this be actually affected? Would it be affected by the Highway Authority and the developer would pay, or?
So it would be carried out using Section 278 works as per sort of off-site highways requirements under Section 278. Our only comments there is in relation to what's in brackets at the bottom as to whether or not that's really needed within there, because ultimately a commuted sum would be provided as part of the Section 278 process anyway.
I think that condition might need to be reworded slightly, because, I mean, for a start, that is sort of more of an advisory, that bit in brackets. It's not really a condition.
Yeah.
And I think perhaps the condition needs to make clear that, obviously the element that requiring that it's provided prior to first occupation is fine, but maybe we need to refer to Section 278. That it would be effective through the 278 process. Because, I mean, would that essentially mean that the Highway Authority would actually build it, and then the money would be provided by the developer, presumably?
Yeah. It means that you're also reliant on them to build it before you can.
Exactly, yeah, which is an ongoing. I think the only problem is referring to you then have an agreement on an agreement, then, wouldn't you? Which could be complicated. I mean, I think it would be easy just to take out what's in the brackets.
Yeah.
Because the reality is we need those 278.
Well, maybe you should just say prior to the occupation of the development, a zebra crossing shall be provided in accordance with da-di-da-di-da. Do it that way.
Yeah, absolutely.
So that would just make sure that it's provided, and then it's up to the liaison between the parties.
Yes.
That would probably be a way of dealing with that, rather than saying the developer shall implement, because that's not strictly.
That's true. It's a good point. Yes.
Not strictly right, is it? Okay.
Oh, sorry. Apparently your microphone's off.
Oh, sorry.
Thank you.
I'm probably not being broadcast to the world then if I'm not on. Yeah. So just to reiterate, I said that the zebra crossing shall be provided prior to the first occupation of the development, rather than saying the developer shall provide, because it's not actually the developer who will implement the works. They may well pay for the works, but they're not actually getting out there with their spades and digging the road, as it were. Right, good. Okay, well, 36 we dealt with. That was that's the southern access. And 37. Now this one, I wasn't sure about this one, because it says prior to the first occupation of the southern parcel of the development, the applicant shall submit a scheme for approval for the provision of 2 new bus stops. Is that something that the applicant would do, or is that something that would be?
It will be done in conjunction with, because whilst we've shown theoretically where those bus stops are going to be, the exact position of them will be something we'll have to discuss with the Highway Authority and the bus. Is
it the Highway Authority, or is it the bus?
It's the bus
services.
I think they'll all get involved.
Right.
If it's on highway land and there's a bus operator, so it'll be.
Is that a matter for the local planning authority to approve, though? If it's bus stops, I mean, I don't know. I didn't know that local authorities get involved with bus stops.
I think because the 106 has a contribution towards improving bus services past the site. I think in order to ensure that there was another bus stop within a closer vicinity of the scheme, that's why that had been requested, because the two go in tandem, as it were.
Right. Okay. Well, if that's the case, I mean, I understand why it's needed. Okay, that's fine. So yeah, I mean, what would be helpful is if, as I say, if you could perhaps redraft these in the light of the discussion that we've had, and yes,
apologies. There is one that we've forgotten, and apologies, I don't particularly want to add another condition, but we've already discussed the approved plans.
Oh, position. Thank you for reminding me. Yes, of course.
And, as in a lack of them, And Jeff, you've got the list there, so it's probably worth you reading them out. But effectively, they cover the site accesses, location plan, and framework plan.
Site access.
If it's easier, sir, it's in Appendix 1 of the Statement of Common Ground. It's those 4.
Yeah. No, you're quite right. This is something I mentioned when we were dealing with the evidence, that clearly there does need to be a fundamental condition that ties the any scheme to the site, the actual site plan, including the site accesses. I mean, I'm wondering whether those two conditions. No, I suppose they're requiring the provision before occupation, aren't they? So that's slightly different. But yeah, no, I mean, we certainly need an approved plans condition. So that should be up near the beginning.
Can I just also flag? I think it was. Well, I'm sure it was raised yesterday by Mr. Cannock, and I think it's been raised before as well. But in the Statement of Common Ground, there is a paragraph that just explains the position around the various plans that were submitted. Right. Because essentially there were plans submitted but weren't necessarily part of the determination. Right. So it's paragraph 3.8 of the Statement of Common Ground just clarifies that position. So I don't think we have any major issues.
No. Well, I think we discussed this at the case management conference, the amendment, didn't we? I seem to recall. And I think Mr. Johnson, who was on the call, the head of development control, development management, confirmed that he was happy with the substitution of any plans. That was my understanding of.
It wasn't around the substitution of plans. I think that was agreed. This was around what was actually part of the application that was submitted. Right. So as I said, the position is summarised in paragraph 3.8.
Right, I haven't actually got that to hand at the moment. So do you want to just read it out?
Yeah, certainly, yeah. So it says, a schedule setting out the documents and drawings that were submitted by the applicant is contained at Appendix 1. Whilst this indicates that drawing number A121B, which is the Framework Master Plan, was submitted for approval, the application itself indicates that the only matters for which approval is being sought as part of the outline application relate to access. As a result, the Council has determined the application on the basis that the Framework Master Plan provides indicative information on the likely spatial parameters for the proposed development. Proposed Condition 1 in the Officer's Report makes clear the details of the appearance, landscaping, layout and scale are to form part of reserved matters applications to follow. In addition, the decision notice issued by the Council makes no reference to drawing number A121B, which is the Framework Master Plan.
So what's in a nutshell, what's the point that you're making?
Well, the point there is just around what the Council was determining when it determined the application and the status of those plans. I think we understand the logic in referring to the Framework Master Plan. I just wanted.
So you're saying that wasn't before members?
I believe it was before members. It just wasn't part of.
Part of the application was part of the submission. It just wasn't referenced in the committee report.
Yeah.
Right.
To members, but it's always been part of it. It's been part of the reconsultation we did, and it's been part of the appeal bundle all the way through. So it's a plan which people are aware of. And clearly it's the best way which we can then secure the delivery of the open space, which we talked about yesterday. Also identifies the location of the office hub and the.
I mean, I'm not quite clear, Mr. Coleman. Are you saying that they shouldn't be included then, or what are you saying?
I think I'm just raising raising the fact that I don't think that they were determined by the Council I don't think when the Council determined the application that they were necessarily aware of the status of those plans. So if they were only considering that the application was outline only, so outline only looking at access, then they may not have realised that they were determining that plan as the Framework Master Plan.
I mean, I would have thought their concerns were more the principle of the development of the site rather than any framework plans. Frankly,
Absolutely,
I mean, I don't think their decision was. I mean, I can't speak for the committee, but it seems to me that their fundamental problem with it was the fact that there's 160 houses proposed on an area that's currently a green field. That was their problem. No, well, I mean, it seems to me a matter that you need to resolve, but it seems to me that we do need to have some means of tying down any, in the event I was minded to allow the appeal, we need to have some means of tying the development down. And I mean, I think it was helpful that the appellant, Mr. Armstrong, agreed earlier on in the sessions that they were happy to have some kind of framework plan that secured the eastern landscaping buffer. Yeah. Because it seems to me if we don't include that, then frankly, it's worse for the council than if it's included.
I think it's more just wanted to flag it up procedurally that I don't know that was identified in that way at the time in the application, but I think we agree that it's useful, it's beneficial to tie down those land uses. No,
I mean, I think given that that's the way the application was submitted, the more any permission is, tied down. Obviously, a lot of Mr. Milcreast's evidence was predicated on this notion of an eastern, buffer. Now, my concern was that if there's no plan included in any condition, then that wouldn't be secured.
Yeah.
So, yeah. Okay.
Yeah.
Just to add, what I would say is in the planning balance section of the officer's report, in paragraph 5.4, apologies sir, I don't have the core document reference to hand, the officer does state that one of the main benefits of the proposal are the environmental benefits of the development as a result of the enhancement and provision of landscape and ecological features. Mm-hmm. So it's clearly in there from a benefit point of view in that regard.
Yeah, I mean, I would have thought, as I say, were I minded to allow the appeal, it would be, to the council's advantage to have the development tied down in a way that would ensure some sort of buffer, rather than not having it included.
No, we agree with that, sir.
Yeah,
and we support that as well.
Okay, good. All right. Well, I'll leave that with you then. I don't know how long you want how long you need to work on the schedule. I mean, I'm happy to give you a few days if needs be. I mean,
just Wednesday next week to submit it. Is that too far? I mean, we're quite flexible, so up to you guys. If you
so Friday of next week.
Yes.
Yeah.
Okay.
Agreed.
That gives you over a week, so it should be enough time, I would have thought. I mean, to be honest, a lot of the changes, although it probably sounds like a complete rewrite, I mean, I think it should be reasonably straightforward to do. It would be helpful as well if they can be emailed to Mr. Wordsworth at the Planning Inspectorate. So I have an electronic copy of it. That would be most helpful.
The council will add that to the portal as well. So, yeah.
Okay, jolly good. All right. So that deals with the conditions. I mean, in terms of the legal agreement, I don't particularly have any comments. I don't know if it essentially. I think Mr. Cannock's opening submissions, he sets out in his opening submissions, the various matters that would be secured by the obligation, and so that it seems to me relatively clear. There's a schedule relating to affordable housing, which requires that not less than 50% of the dwellings shall be provided as affordable housing, and it gives a split of how the dwellings are to be provided in terms of social rented housing and intermediate housing, and there's a lot of technical detail on nomination rights and so on. So that's the affordable housing element. There's a provision relating to local open space, again requiring that to be provided as part of any proposal, and there's provisions relating to the maintenance of that open space. There's also a requirement for a local open space specification and local open space maintenance plan. There's also provisions relating to the day nursery that that should be provided, that the developer and owner covenant to market the day nursery and use reasonable endeavours to enter into a binding contract with prospective end users of the day nursery for a period of 12 months. And then it's, as I understand it, if it's not provided within that period, then it reverts to local open space. Is that essentially?
That's correct, sir.
Yeah. And then we have a schedule on first homes.
Sir, sorry, can I just raise on the fourth schedule, which is just before it's got two items. One is the Essex Coast Rams, and one is the contribution to the NHS. Mm-hmm. I just noticed that the Essex Coast Rams contribution isn't specified, and I think everything else in the document is. Mm-hmm. So I just didn't know if that needed to be added.
Sorry, it's not expressed?
The actual contribution itself, it doesn't say what it is, how much it is.
Ah.
It just says the contribution.
Oh, okay. Is that not defined in the...
Is it defined somewhere?
The contribution will ultimately depend on the number of dwellings. So.
But in the other cases where that's the case,
it is defined.
Okay.
Some comprising £156.76 per dwelling as a contribution towards the mitigation of the harm caused to those sites protected by the habitats regulations.
Okay, thank you.
Okay. And then Schedule 5 deals with first homes. So there's a series of definitions in that section. I've not got any particular comment on that. And then moving on to the sixth schedule is a requirement for a residential travel plan. So this is a travel plan is essentially a plan to include measures to ensure sustainable means of travel are available to residents of the development. Fairly standard requirement in new residential developments. So nothing to say on that. And then we have the bus service contribution, which requires a payment to the county council for bus services.
Sorry, sir. What I would add on that point, I think Mr. Canuck, when we were having the discussion around the openings, mentioned that we may have had some concern on the bus service contribution. I think we didn't have a concern per se. It was more in the absence of the charging schedule document that we hadn't seen the text that went in that in terms of how it was spent. And I can confirm we're perfectly happy with that now. Having seen
that's helpful. Thank you. And then the seventh schedule relates to education contributions. So that sets out what contributions would be payable. I assume these are all agreed with the relevant authorities. And then the we have the library contribution, which is a sum per dwelling that will be paid, again, I presume, to the county council. And then the 8th schedule relates to the office hub, and that is required to be constructed before 80% of the dwellings are provided. So, yeah, I mean, as I understand it, the provisions are essentially agreed between the various parties. So I've got, you know, no further comments on that, really.
Just in terms of the status of it, sir, so it's been signed by the landowners, by Catesby and County Council, and therefore it's just the district to sign and seal. And I'm assuming, bearing in mind you have no comments, that will happen in the next day or so, or whenever the sealing.
Yeah, I mean, there's no, again, I mean, I don't know whether it has to be signed by the mayor or something. Sometimes these things take, sealing process takes time. But I mean, given that you've agreed to provide the conditions within a week, I'm happy to grant at least a week. I mean, if you need longer than that, then let me know.
Sorry, sir. Just been flagged up to me that there may be an omission.
Contribution.
Okay, I think it is there. Sorry, just bear with me 1 minute. Apologies.
The NHS contribution is defined in the front.
I mean, if you want to just liaise with each other outside this forum, as it were, if there's any particular, I mean, I had a read through it last night, and there was nothing that sort of jumped out at me as being erroneous. But I mean, if you by all means, if there are any sort of any text that needs to be tightened up or whatever, then that's fine. I mean, as I see it, it's the main provisions are clear, and so that, you know, that's as long as the fundamental provisions remain the same. You know, if there's changing to the wording or whatever, that's absolutely fine. And I think you've provided a SIL compliance statement which sets out why these things are necessary. So, yeah, good.
Sorry, sir, there are a couple of changes we need to make to the SIL compliance statement, so somebody's looking at those today.
Okay, well, if that can be sent to me,
certainly,
in due course, that would be helpful.
Absolutely, yeah.
So, sorry, just to ask, do we know which areas that there may be changes in?
The issue that was raised was, I think, to do with the health contribution, and that, as I see it, is in section 4. Yeah. So I think it was. I think it's fine. I don't think there is an issue. Right. Oh, sorry. On the SIL compliance statement. Apologies. Sorry. No. Well, I just noticed when I looked at it last night, page 7. I mean, it's a copy and paste error as opposed to a major issue, I believe. But it's financial contribution to the library. It then refers in the 3rd column to secondary school places. So it just needs to be double checked. That row that talks about library provision, and there's a couple of references to secondary education provision.
I see what you mean in the middle column.
Yeah. And at the end of the 1st column as well.
All right. Well, look, I'll leave you to rather than take up inquiry time, I'll leave you to sort that out between you. As long as the SIL compliance statement explains why, you know, that certain contributions have been asked for, and you know that's all I need, really. So if there's certain details that you need to resolve, then I'll leave you to do that.
Merely simple admin from what we've done.
Indeed.
Nothing major.
I seem to have been provided. It looks as if these are the comments. Are these the comments of the changing the subject? The Latchingdon Parish Council comments.
So you wanted a copy?
Yes,
of my
thank
reference,
you.
So I've given you a copy in the council.
Yeah, no, thank you very much, Mr. Armstrong. I'll give that an inquiry document number. I'm not quite sure what number we're up to, but that it wasn't. I think that was in your examination, wasn't it? You raised the point about the comments that they'd made, and I don't think they were previously before the inquiry. They were merely summarised in the officer's report. So, thank you for that. Are there any other procedural points anyone wants to raise now?
I'll just reiterate the council's agreement yesterday to provide you with the details of the residents who offered views from their gardens.
Indeed.
I haven't forgotten that. I just haven't. It just isn't done yet.
Yeah.
So
thank you.
That will be dealt with.
Mr. Wilcox. I will arrange a site visit in due course. I'm certainly not proposing to do it today in these conditions. I'll yes. If you provide the case officer with the details of any residents that wanted me to view it from their property, that would be very helpful, and I'm happy to do that with the appellant's agreement unaccompanied, and I'll make it clear to those whose property I visit that I will not be open to hearing any submissions from them.
That was a message I stressed in the discussion with them as well. So.
Yes, indeed.
And so I've seen a note which is going to be circulated from Mr. Milcreast on the site visit itinerary, so that can be circulated as well.
Yes, thank you, Mr. Cannock, for that. That would be most helpful if a site route, as it were, could be provided for me to follow. That would be very helpful. Thank you.
Sorry, sir. Just apologies for interrupting. The only comment we've got is in relation to that is as the land is obviously farmed. So that we're copied into the correspondence to Mr. Wordsworth in terms of the details and the dates,
sure.
Just so I can inform the landowner that you'll be on site and gates can be left unlocked.
Are there any sort of cows or anything on site at the moment? No. Is it arable, isn't it?
Yeah.
Yes. I did a recent site visit where I was confronted with a sort of herd of cows charging towards me, which wasn't particularly pleasant.
Not conducive to a good.
I assumed that it was sort of predominantly arable. Yeah, no. No, it's you sort of hear these terrible stories of people being trampled to death. So I wanted to try and avoid that. Are there any other risks I should be aware of on site?
No, not aware of.
No. But as I understand it, Mr. Morris, you're happy for me if I need to go on the site.
Correct. Yes.
Yeah. Thank you.
It is no doubt after today and
muddy.
Yes,
muddy.
So
yeah.
I'll take a good pair of.
I always carry Wellington boots in the car for these purposes. Okay. Well, thank you very much. As I said in opening this morning, we've agreed that the closing submissions will be done in writing. I don't think that puts anyone at a disadvantage. I've asked the council to ensure that the closings are uploaded onto the council's website so that they will be available for everyone who's interested to read. Essentially, what the closing submissions do is they just summarise each party's argument. So Mr. Wilcox will put his in first, and then the appellant, as is the tradition in these situations, will put their submissions in afterwards, and that's been agreed. So that's very helpful. So, are there any other points anyone wants to raise, Mr. Wilcox or Mr. Cannock?
No, sir. Other than on behalf of both parties, thank you for allowing Malone and Friend and I a degree of latitude in presenting our cases. I think it's allowed us to deal with things very quickly, if I may say so. And thank you for allowing us to get it done so quickly. I appreciate
absolutely
it.
Echo those comments.
Well, thank you, Mr. Cannock and Mr. Wilcox, for your contributions. You've been extremely helpful in facilitating the inquiry in a very efficient way. So I thank you both for that, and I also thank all the participants that have, Mr. Coleman, Mr. Armstrong, Mr. Morris, and people who have attended as well. Thank you for showing an interest. As I said to you all earlier, I'm very aware of the there's a lot of objection on this particular scheme, so I will obviously be considering everyone's objections very carefully and before reaching a decision. So, but thank you all for your contributions over the last few days. Once I've received all the outstanding documents, I'll then proceed to a decision in due course. I can't give you a firm outline as to timings at this stage, but hopefully I'll be able to do that in due course once I've received all the documents. So that will conclude proceedings in the chamber today. So thanks all for coming, and I will close the inquiry formally in writing once I've received the various documents. So thank you all again, and I'll adjourn rather than close the inquiry, and I thank you all for attending. Thank you.
Thank you, sir.